Hello. In this clip from our Justia webinar, AI and Ethics, Using Artificial Intelligence Responsibly in Legal Practice, James Gatto highlights the importance of confidentiality and competency when using AI. If you'd like to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
So the first couple relate to competency and confidentiality. So as we're all aware, attorneys must represent their clients competently. And part of this is that you have to have an understanding of the risk and benefits of technology used in connection with legal services. And this is not new. We've seen this when lawyers started using email and e-discovery and cloud storage and storing information on personal phones and other devices. There's been a constant flow of new technologies over time that have created considerations for lawyers and how to ensure that you can use the technology in a way that doesn't violate any of the ethical rules. This is some examples of kind of prior decisions by that have come up in different states, protecting metadata in transit. There's a California opinion that says if you don't have the requisite skills, you have to either hire someone who does, develop the skills, or decline representation. Various other prior decisions relating to use of technology, including in some states now, there's a requirement for technology training and other requirements to stay competent with respect to the technology that's used. Some of these slides are kind of dense. I'm not going to go through them all. A lot of this is kind of to leave behind for you as far as additional information. So I'll just touch on some of the relevant points in some of these more dense slides. The California bar, makes it clear they specifically call out generative AI and making sure that lawyers understand how it works. And as we'll see, if you're not already aware, if people use the term generative AI broadly and as kind of an umbrella, there's many different tools that fall into the scope of generative AI. And one of the reasons that there's a focus on generative AI versus other AI or other machine learning related tools is in part because, as the name implies, the generative AI tools create new content. So AI is not new. AI has been around since the 1950s, actually. It's a 70-year-old technology. It's really starting to see its limelight because of generative AI. And one of the big differences from a simple explanation to help people understand if it's not clear the difference between generative AI and other types of AI is that a lot of the AI up until the last couple of years was really more what's referred to as deterministic. So a lot of it you could think of as analogous to being rules-based. So someone coded in rules and the AI or the machine learning technology would crunch a lot of data in accordance with those rules and produce some output. And those outputs were typically very predictable. As long as the rules were coded properly, you could get an output that if you did it manually, you would likely get the same result. And that's what's meant by deterministic, at least at a high level. With generative AI, these tools really do create content. It's not just regurgitating what it's learned. You may have heard the term training of AI models. The AI models are complex. I won't go into a lot of the technical detail, but it's not just taking a lot of content and storing it and then later retrieving it. It's actually training a model using what's called model weights, and the more content that you train on, the more accurate or the more useful these models become. And so when you put in a prompt to say, give me or do legal research on this particular issue, it will not only it will do the research, but it'll actually be able to format the results, distill the information, and create a draft memo for you, as one example. And so while a lot of these tools work well, they're not perfect. And one of the biggest problems is that in some cases, as we'll get into in a second in more detail, these tools actually make up information, right? Because it's not always pulling current information. It's generating stuff based on what it thinks it knows. And this is sometimes referred to as hallucinations. And we'll come back to that in just a second. So what's important to understand is how these tools work, because the way these tools work is that when you provide an input and the tool does its thing and it provides an output, is that sometimes those inputs and outputs are used by the tool to improve itself. So if the inputs are retained and the outputs are reviewed to see if the output was useful or helpful, that can be used to retrain the models in some cases. But the downside to that is you potentially, depending on if you have any confidential information in the input, if that gets sucked into the AI and used to retrain it, some of that information can get output. And there's been situations where that's happened. But these tools work in different ways, and so not all of them work that way. So that's one of the most, I think, critical things to understand is how does the tool work? How does it process inputs and outputs? Does it reuse them, or does it discard that information after it provides you the answer that you're looking for? And we'll look at that and see how that impacts a couple of the ethical rules here in a second. So when we think about, as a lead into this, part of this is a requirement that you, of course, can't disclose confidential information of clients unless there's consent or in other limited circumstances. So as I just mentioned, when you use certain AI tools, if your prompt or input to the tool includes anything that would be confidential information, you need to make sure that tool does not retain that information or reuse it. So that's kind of one of the number one things, I think, from a confidentiality perspective that's important to understand. And pretty much all of the guidance that I've seen clearly addresses this point. And so it's important to not only understand this, but also we'll talk a little bit more later on about developing policies. In many cases, it's helpful, even if you're using a tool that you're confident doesn't reuse the prompts, right? And so you're not impacting any confidential information. In some cases, it's prudent as an extra safeguard to try to avoid using anything confidential in the inputs in the first place, in case there's any anomalies or if you have misunderstood the tool, how it works, etc. So instead of using a specific company name, for example, you might just give a fact scenario without tying it to a company, right? That's a very simplistic explanation or example, but you can envision how you can create prompts that may not have specific confidential information, but you can still get the kind of information you want out of the tool. So that's kind of one of the considerations for confidentiality. So how do you go about determining how these tools work? It's really a combination of things, and it's kind of a layered approach. So first and foremost, most of the companies that are providing legal tools understand the ethical obligations, and most of them are designing their tools so that they're legally compliant and lawyers aren't going to have a problem using them. Those are the legal specific tools, but there's also kind of general purpose tools. And throughout this presentation, I'm not really going to do a lot of talking about specific tools. So I don't want to advocate for or denigrate, specific tools in many cases. But it's important to understand that some of the general purpose tools, there's different versions of those tools. There's a free version and there's a paid version. And in many cases with the free version, they will reuse your inputs, and they'll tell you that. In some cases with the paid version or the enterprise version, they won't. Now, some of those tools, again, are not legal specific, but lawyers use them because they're general purpose tools and they can provide useful benefits. So the first thing to understand is what's the nature of the tool, right? And the second is how do they market it? What do they say about it? But you need to look beyond the marketing materials, because there have been situations where marketing has not been necessarily 100% clear or transparent, because some of these issues with general purpose tools aren't specifically addressed. So how do you dig deeper? So one of the things to look at is the terms of service and privacy policy of these tools. So as lawyers, we love looking at legal documents. Many times the tools will, in the terms of service or privacy policy, will tell you how they handle the inputs. And in some cases, what you'll see is, like with some of these tools, it will tell you that they use it, or that you grant them a license to use your inputs, if it's with certain versions of the tools. So you can get clues from the terms of service and privacy policy as to whether there's, legal risks with these tools. And in some cases, you may want to just do some more technical diligence. We have a technology team that vets all the tools that we use, in addition to these other layers of things that we look at. And most firms are doing that right now as well. So, those are some of the ways in which you can kind of drill down from like marketing to legal documents to doing a deeper tech dive on the technology to understand how they work and whether the confidential information is being preserved. This is an example I'll just give. And again, well, I'm not going to focus on too many tools, specifically ChatGPT. Their terms of service are very clear. Again, this is a general purpose tool, not a legal specific tool, but they make it clear that they don't use your content if they receive it through an API, which you do that if you have an enterprise version. But it says we will use your content from other non-API services, basically. So if you're using the consumer or free version where you're typing stuff directly in to a web browser through ChatGPT or a mobile app, you may be exposing confidential information. So that's just a very simple, clear example from a terms of use that make this distinction clear. And so those are the types of things that you want to look for in the terms of service. Okay, so this is just some additional information from New York. I'm going to skip over that. California, again, there's a lot of guidance specifically on generative AI products. They talk a lot about the prompts that are used. And they also talk about uploaded documents or resources to train the AI. And I want to focus here for a second again on another technical distinction it's important to understand, is that for a lot of these legal tools, they're trained on legal documents. So it could be SEC filings, it could be other public documents that they're using where the model is initially trained. There's a technology that works alongside of these trained AI models that's referred to as retrieval augmented generation. And if you're not aware of it, I encourage you to dig a little deeper into it, because it's a very powerful technology, and it's something that actually a lot of law firms are using. And the way that retrieval augmented generation works, or it's called RAGs for short, as the acronym for RAG, is that, think of it like this. So you've got a trained AI model, you've got an AI tool that you typically provide prompts to. With RAGs, what you're doing is you're adding to that a set of documents, and typically it'll be your own documents, so internal firm documents, or it could be client-specific documents. There's different ways to configure a RAG system with these different parameters. But in general, what happens is, if you've got a library of documents that you've used, prior forms or other agreements or whatever the case may be, that you like, and you want to use those as part of improving these AI tools, you can use this RAGs technology. And the way it works is, if you provide an input to the tool and say, create a draft of a confidentiality agreement, and then you can put in whatever other parameters you want for that input, what'll happen is the AI tool will first do a search of the document library that's in the RAGs library. And it will find, just like you would do a traditional search, it will do a word search, it'll find the relevant documents, and then it provides those documents with the rest of your prompt to the AI tool. And that combination of information is used to produce a first draft of this confidentiality agreement. So one of the advantages of this is that while many AI tools could create a draft confidentiality agreement without the RAGs part, by using the RAGs part, it's going to kind of what's called constrain the input so that you're getting a version that's based on what you've done before. So hopefully that's kind of clear enough. So it's important, a couple of things that's important to understand with RAGs is you can use your own document or a client-specific library if you're doing something for the client if they have a certain set of forms. It doesn't retrain the AI model, it just uses it alongside it. And so one of the reasons I go through a long explanation on that is because these are how a lot of the AI tools, legal tools are working or will work, because having something that's just generally trained is useful. Having something that can use documents that you know that you've used before that are well vetted and may have specific provisions that you like is even more helpful. So one of the things that's important to understand, though, is you wouldn't want to use, you may not want to use, depending on the facts, documents that you've used for one client, if let's say there's any confidentiality in it, in a RAGs approach where you may be outputting stuff that's being used for another client. So that'd be an example of where you could have a leakage of confidentiality with a RAGs type system. Another situation, and I may have a slide on this later on, but I'll cover it right now, that's important to understand is that if you have an ethical wall set up within your firm where certain lawyers can't get access to certain documents, you need to implement that in connection with the RAG system. So what I mean by that is if there's a team of lawyers who can represent client A but can't see information from client B, you wouldn't want to have the lawyers on the team for client A be able through a RAG system to access firm documents that were associated with client B. So that's an important limitation that needs to be implemented with a RAG system when you're using it within a law firm.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next clip.